Good evening, friends. Welcome to my legal class. Today, we will continue our discussions regarding independence of judiciary. Now, we will discuss about removal of judges. How, by removal process, our constitution ensures independence of judiciary. What is the process for removal of judges? One thing is remember that the judges are appointed by president. Once appointed, the judges hold their office till the age of 65 in case of Supreme Court and 62 years of age in case of High Courts. That is till their retirement age. Once they appointed, it is highly impossible for remove the judges. Under Article 124 Class 4 provides two grounds for the removal of the judges. Those are proved misbehavior and incapacity. Only on only on these two grounds judges can be removed, and not for easy to remove. That is, removal motion should be passed in the parliament by two-third majority, that is present and vote by the two-third members of the both the houses, upper house and lower houses, in favor of impeachment. Then only it is possible to remove the judges, but it is not possible in our India so easily to prove the misbehavior and the incapacity, because in our constitution what is misbehavior, what is incapacity is not explained in detail. That is the reason why under class 5 section 124 provides the provisions. Parliament can make law or provisions for the for the enquiry of the judges removal process. So that is why our parliament enacted Judges Enquiry Act. Under that act, so many provisions are provided for the removal of the judges. According to that, the process will be takes place in the parliament. So almost it is highly impossible to remove the judges. Inquiry must be conducted for against so many judges, but it is not proved in the parliament, and two-third majority will not in favor of removal of the judges till now. So it is the lengthy process, and it is highly impossible to remove the judges. Next one. So this ensures the independence of judiciary, protection of judges in our constitutions, so that they can, without any fear of their removal by the political leaders, they can work confidently, so they can uphold the rule of law. Next advantage, next protection of judges is the judicial proceedings of the judges is not discussed in the parliament. It is that is, they were immune from discussions in the parliament in case of Supreme Court judges proceedings. In case of High Court's judicial proceedings were not discussed in the state legislature. It is immune from such acts by the judges. So this is the protections provided to the judges to conduct their functions without any fear. And one thing is, kindly understand here, the independence of judiciary is only for judicial functions. What is judicial functions? Determination of disputes and giving verdicts on that basis is a appointment of judges is the judicial function? The answer is no. That is purely an executive action. But the consultation of CJI is given in our constitutions because to protect the judiciary, protect the independence of judiciary. All these provisions provided in our constitutions, so that judges were freely function, freely work, and freely they deliver their judgment. Judgment should be always free and fair, reasonable. So it is very essential, sine qua non, means it is one of the independence of judiciary is one of the essential characteristics of the constitutions to uphold the rule of law. It is the our judiciary is the protector of the constitutions. One thing is remember here, not only the independence of judiciary, they must be impartial. They work without any favor. So the constitutions made the provision that after their retirement, constitution banned the practice as an advocate by the retired judges. Retired Supreme Court judges are not permitted to practice any court in the India. Like that, retired judges of high courts are not permitted to practice in the high court where they were retired, and the lower courts they can practice as an advocate in Supreme Court and other high courts. So why these provisions? What is the purpose behind these provisions banning on practice of the judges as an advocate? That is, after their retirement, if the judge plead before the bench in the same court where they were retired, it may influence on the judgment, because it is presumption that they were all familiar with them. So court bans on the practice of the judges in the same court. Like that, they may favor the judgment during their period for the past appointments, for past advantages. So one thing is consider here, our constitutions prohibits the bans the practice of retired judges, but they were occupy the government offices, other posts, post retirement appointments. We were look at that the so many retired judges are appointed as governors, as Rajya Sabha members. So that is the reason why our Law Commission report recommended that after a retirement of the judges should not be appointed in the government offices. They may, because for their future benefits, it is influenced on the judgment. Amazingly, look at that, so many judges are involved in important judgments just before their retirement. Shortly, they were occupied the government offices after their retirements. Look at this. So, our Law Commission report recommended for the banning on appointment in the government offices after their retirement. So, understand why the constitution provided independence of judiciary in various provisions of our constitution, because it is very essential for the judiciary to uphold the rule of law, protect the democracy. Ours is welfare state. wider power is given to the legislature to run the government. They may abuse their political power. So, independence of judiciary is very essential to where the law made by the legislature, if those laws violates the constitutional values, that laws must be made the null and void by the judiciary. So this is the judicial review power is provided in our constitution to the high courts and supreme court. It is one of the weapon in the hand of the judiciary to make the laws null and void if they violates the constitution provisions, to uphold the rule of law, protect the fundamental rights. It is very essential. So this power, judicial review power, is provided under article 226 and 227 for high courts, and 3 and under 32 to the supreme court, 32 and 136 to the supreme court. So it is one of the weapon to the judiciary to protect our constitution, guardian of our constitutions. So independence of judiciary is very essential. Even independence of judiciary for judicial functions, even though the executive functions, administrative functions such as appointment of judges will be performed by the judges. With the consultation of the judges only, judges are appointed in our country. This is to protect the democracy only. So this is the end of the class. We will meet you in the next class with new concepts. Till then, bye. Thank you.